Question 1. Upon reviewing the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements, a retired law enforcement officer residing in California needs to determine the precise steps necessary to legally carry a concealed firearm within the state. What is the most prudent approach for this officer to ensure full compliance with all applicable regulations? Option A. Proceed with carrying a firearm based on a general understanding of LEOSA, assuming their initial federal qualification remains valid indefinitely without further confirmation. Option B. Rely on informal advice from other retired officers or online forums that discuss LEOSA implementation in California to understand the necessary steps. Option C. Assume that the federal LEOSA qualification automatically satisfies all carrying requirements in California, as the federal law supersedes state-specific nuances. Option D. Proactively verify the specific requirements for LEOSA qualification in California, including any state-specific training, documentation, or renewal processes that may exceed federal minimums, by consulting official California Department of Justice resources or seeking guidance from their former agency. Correct answer is D. Proactively verify the specific requirements for LEOSA qualification in California, including any state-specific training, documentation, or renewal processes that may exceed federal minimums, by consulting official California Department of Justice resources or seeking guidance from their former agency. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an officer to navigate the nuances of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements, while also considering the specific state laws of California that may impose additional or differing stipulations. The core challenge lies in ensuring compliance with both federal mandates and state-specific regulation, which can sometimes create ambiguity or require careful interpretation to avoid legal or disciplinary repercussions. The officer must balance their right to carry under LEOSA with the responsibility to adhere to all applicable laws. Correct approach analysis. The best professional practice involves proactively verifying the specific requirements for LEOSA qualification in California, including any state-specific training, documentation, or renewal processes that may exceed the federal minimums. This approach is correct because LEOSA explicitly allows states to enact laws that provide greater restrictions on the carrying of firearms by qualified former law enforcement officers. California, like many states, has its own set of regulations that govern firearm possession and qualification for retired officers. By consulting official California Department of Justice resources or seeking guidance from their former agency's legal counsel or HR department regarding California's specific interpretation and implementation of LEOSA, the officer ensures they are meeting all legal obligations. This proactive verification prevents potential violations and upholds the spirit and letter of both federal and state law. Incorrect approach is analysis. One incorrect approach is to assume that federal LEOSA qualification automatically satisfies all requirements in California without further inquiry. This is professionally unacceptable because it ignores the possibility of state-specific regulations that may impose additional burdens or different qualification standards. Relying solely on the federal statute without considering state law can lead to noncompliance with California's penal code, potentially resulting in legal penalties or the revocation of carrying privileges. Another incorrect approach is to rely on informal advice from other former officers or online forums regarding California's LEOSA requirements. This is professionally unsound because such sources may provide outdated, inaccurate, or incomplete information. LEOSA regulations and state interpretations can change, and relying on unofficial advice can lead to misinterpretations and noncompliance, exposing the officer to legal risks and undermining their professional judgment. A third incorrect approach is to proceed with carrying a firearm based on a general understanding of LEOSA without confirming current California-specific qualification status or renewal procedures. This is professionally negligent, as it fails to ensure ongoing compliance with the law. LEOSA qualification often has renewal requirements or specific documentation that must be kept current, and failing to verify this status can result in carrying a firearm unlawfully under California law, even if the initial federal qualification was valid. Professional reasoning. Professionals should adopt a systematic approach to compliance. This involves identifying the relevant federal law, LEOSA, then immediately researching and understanding how that federal law is implemented and potentially supplemented by state law in the specific jurisdiction of operation, California. This research should prioritize official government sources, such as state legislative websites, departmental regulations, or direct consultation with relevant state agencies or former employing agencies. When in doubt, seeking clarification from legal counsel or the appropriate regulatory body is paramount. This methodical process ensures that all legal obligations are met, safeguarding both the individual officer and the public. Question 2. When evaluating their eligibility to carry a firearm under the Federal Law Enforcement Officers Safety Act, LEOSA, in Florida, what is the most prudent course of action for a retired law enforcement officer to ensure full compliance with both federal and state regulations? Option A. Only consider the initial federal LEOSA certification and disregard any state-mandated renewal or recertification processes. Option B. Assume that federal LEOSA qualification automatically satisfies all requirements in Florida without further inquiry. Option C. Rely solely on informal advice from colleagues or outdated information regarding LEOSA qualification in Florida. Option D. Proactively verify Florida's specific requirements for LEOSA qualification, including any state-specific training mandates, documentation, or renewal procedures that supplement the federal act. The correct answer is D. Proactively verify Florida's specific requirements for LEOSA qualification, including any state-specific training mandates, documentation, or renewal procedures that supplement the federal act. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a law enforcement officer to navigate the nuances of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements, while also considering the specific state laws of Florida that may impose additional or differing standards. The officer must balance their right to carry under federal law with the state's regulatory environment, ensuring compliance without compromising their ability to perform their duties or their legal standing. Misinterpreting these requirements can lead to legal repercussions and jeopardize their status as a qualified individual under LEOSA. Correct approach analysis. The best professional practice involves proactively verifying Florida's specific requirements for LEOSA qualification, including any state-specific training mandates, documentation, or renewal procedures that supplement the federal act. This approach is correct because LEOSA, while federal, often interacts with state-level regulations. Florida, like other states, may have its own administrative rules or interpretations that officers must adhere to for their qualification to be recognized within the state. By consulting official Florida Department of Law Enforcement, FDLE, resources, or legal counsel specializing in Florida firearms law for law enforcement, the officer ensures they meet both federal and state mandates, thereby maintaining their LEOSA eligibility in Florida. Incorrect approaches analysis. One incorrect approach is to assume that federal LEOSA qualification automatically satisfies all requirements in Florida without further inquiry. This is a regulatory failure because it ignores the possibility of state-specific addendums or interpretations of LEOSA that Florida may have enacted. Federal law often sets a baseline, but states can impose stricter or additional requirements for carrying firearms, even for qualified former officers. Another incorrect approach is to rely solely on informal advice from colleagues or outdated information. This is an ethical and regulatory failure as it introduces a high risk of misinformation. Professional obligations require officers to seek official, current guidance from authoritative sources. Relying on hearsay can lead to noncompliance with current Florida statutes or FDLE directives, rendering the qualification invalid within the state. A further incorrect approach is to only consider the initial federal LEOSA certification and disregard any state-mandated renewal or recertification processes. This is a significant regulatory failure. LEOSA qualifications are not always permanent and may require periodic renewal, often tied to state-specific training or qualification standards. Failing to adhere to these renewal requirements, as stipulated by Florida law or FDLE, would result in the loss of LEOSA privileges within the state. Professional reasoning. Professionals facing such situations should adopt a systematic approach. First, identify the governing federal law LEOSA. Second, determine the specific state where the qualification is to be recognized, Florida. Third, research the state's specific statutes, administrative codes, and official guidance, e.g., FDLE, pertaining to LEOSA or Retired Law Enforcement Officer firearm qualifications. Fourth, consult official sources or legal counsel if any ambiguity exists. Finally, maintain meticulous records of all qualifications and renewals. Question 3. The analysis reveals that a retired law enforcement officer from the Los Angeles Police Department, who separated from service in good standing and was authorized to carry a firearm during their tenure, is seeking to carry a concealed firearm under the Federal Law Enforcement Officers Safety Act, LEOSA, while residing in California. What is the most prudent course of action to ensure compliance with all applicable regulations? Option A. Focus solely on the federal LEOSA requirements and disregard any potential state-level regulations that might govern the manner of concealed carry for retired officers in California. Option B. Assume that LEOSA federal preemption automatically allows the retired officer to carry a concealed firearm anywhere in California without needing to meet any additional state-specific requirements. Option C. Verify the retired officer's eligibility under LEOSA and confirm they meet California's specific requirements for retired peace officers to carry firearms, including any necessary identification or additional training mandates. Option D. Advise the retired officer that their former agency-issued identification card is sufficient for concealed carry under LEOSA, regardless of its expiration or specific endorsements. The correct answer is C. Verify the retired officer's eligibility under LEOSA and confirm they meet California's specific requirements for retired peace officers to carry firearms, including any necessary identification or additional training mandates. Explanation. The analysis reveals a scenario where a retired law enforcement officer, seeking to carry a concealed firearm under the Federal Law Enforcement Officers Safety Act, LEOSA, in California, encounters a situation requiring careful navigation of state-specific nuances that interact with the federal law. The professional challenge lies in understanding that, while LEOSA is a federal law, its implementation and recognition can be influenced by state laws and regulations, particularly concerning the definition of qualified retired law enforcement officer and the specific requirements for carrying concealed firearms. Misinterpreting these interactions can lead to non-compliance and potential legal ramifications for the retired officer. The best professional approach involves a thorough understanding of both the federal LEOSA provisions and California's specific statutes and administrative guidelines pertaining to retired officers carrying firearms. This includes verifying the retired officer's eligibility under LEOSA, which mandates that the individual must have separated from service in good standing, have been authorized to carry a firearm while employed, and not be prohibited by federal law from possessing a firearm. Crucially, it also requires confirming that the retired officer meets California's specific criteria for retired peace officers to carry firearms, which may involve additional training, identification, or permitting requirements beyond the federal mandate. This approach ensures compliance with all applicable laws and promotes responsible firearm carriage. An incorrect approach would be to assume that federal LEOSA preemption automatically overrides any state-level requirements for retired officers. This failure to acknowledge California's regulatory framework could lead to the retired officer carrying a firearm without meeting state-specific mandates, potentially resulting in legal penalties. Another incorrect approach is to rely solely on the retired officer's former agency's identification card without verifying its validity and compliance with both federal and state requirements for concealed carry. This overlooks the necessity of ensuring the identification meets the specific standards for LEOSA qualification and any additional state-level endorsements or requirements. A further incorrect approach is to interpret LEOSA as granting an unrestricted right to carry a concealed firearm in any state without regard to state laws that may govern the manner of carry or specific identification requirements for retired officers. Even if the underlying federal right to carry exists, professionals should employ a decision-making framework that prioritizes a comprehensive review of all applicable legal frameworks. This involves 1. Identifying the primary federal law LEOSA and its core requirements. 2. Researching the specific state laws and regulations, in this case California, that govern retired law enforcement officers carrying firearms. 3. Analyzing how the state laws interact with or supplement the federal law, looking for areas of preemption, supplementation, or potential conflict. 4. Verifying the retired officer's eligibility against both federal and state criteria, including documentation and any required training or permits. 5. Providing clear guidance to the retired officer on their responsibilities and the specific requirements for lawful concealed carry in the relevant jurisdiction. Question 4. Comparative studies suggest that retired law enforcement officers in Texas face varying interpretations of the Law Enforcement Officers Safety Act, LEOSA, qualification requirements. A retired Texas peace officer who has been separated from service for 5 years is seeking to carry a concealed firearm under LEOSA. Which of the following actions best ensures the officer's continued compliance with LEOSA in Texas? Option A. The officer completes a firearms qualification course administered by a private security firm in Texas, which they believe is equivalent to law enforcement standards. Option B. The officer relies on their initial firearms qualification from their last year of active service, assuming it remains valid indefinitely for LEOSA purposes. Option C. The officer obtains a LEOSA identification card from the U.S. Department of Justice, believing this supersedes any state-specific annual qualification requirements. Option D. The officer completes an annual firearms proficiency qualification that meets the standards set by the Texas Commission on Law Enforcement (TCOL) for retired officers and maintains proof of this qualification. The correct answer is D. The officer completes an annual firearms proficiency qualification that meets the standards set by the Texas Commission on Law Enforcement (TCOL) for retired officers and maintains proof of this qualification. Explanation. Scenario analysis. This scenario presents a professional challenge for a retired law enforcement officer in Texas seeking to carry a concealed firearm under the Law Enforcement Officers Safety Act, LEOSA. The challenge lies in understanding and correctly applying the specific requirements for retired officers to maintain their LEOSA eligibility, particularly concerning the annual firearms qualification. Misinterpreting these requirements can lead to an officer unknowingly violating federal law and potentially facing legal repercussions, undermining the very purpose of LEOSA, which is to allow qualified retired officers to carry firearms for their continued protection. Correct approach analysis. The best professional practice involves the retired officer proactively understanding and adhering to the specific qualification requirements outlined by the Texas Commission on Law Enforcement (TCOL) for LEOSA eligibility. This means ensuring they complete an annual firearms qualification that meets the standards set by their former agency or TCOL and maintaining documentation of this qualification. This approach is correct because it directly aligns with the intent of LEOSA and the implementing regulations, which require a retired officer to have been found qualified to carry a firearm by their former agency and to have completed a firearms proficiency test and requalification within a specified period. Texas law, through TCOL, provides the framework for how these qualifications are to be met by retired Texas peace officers seeking to carry under LEOSA. Incorrect approach is analysis. One incorrect approach is to assume that simply being a retired Texas peace officer automatically grants perpetual LEOSA eligibility without any ongoing requirements. This fails to recognize that LEOSA, as interpreted and implemented by states like Texas, mandates periodic requalification to demonstrate continued proficiency. The absence of an annual qualification means the officer is no longer meeting the federal standard for being qualified to carry a firearm. Another incorrect approach is to rely on a qualification from a different state or a non-official training course that does not meet the specific standards required by Texas for LEOSA. LEOSA allows states to establish their own qualification standards, and a retired Texas officer must meet those specific Texas requirements. A qualification from another jurisdiction or an informal course may not be recognized by Texas authorities or federal law for LEOSA purposes in Texas. A third incorrect approach is to believe that a LEOSA identification card issued by the U.S. Department of Justice is a standalone document that negates the need for ongoing state-level qualifications. While the card is evidence of eligibility, it is contingent upon the individual continuing to meet the underlying federal and state requirements, including the annual firearms proficiency. The card itself does not exempt the holder from the necessity of maintaining their qualification status. Professional reasoning. Professionals in this situation should adopt a proactive and diligent approach. This involves thoroughly researching the specific requirements for retired law enforcement officers in Texas seeking to maintain LEOSA eligibility. This research should include consulting official resources from TCOL and understanding the nuances of federal LEOSA provisions as they apply to retired officers. When in doubt, seeking clarification from TCOL or legal counsel specializing in firearms law is advisable. The decision-making process should prioritize compliance with all applicable laws and regulations, ensuring that any firearms qualification undertaken is officially recognized and documented according to the established standards. Question 5. The investigation demonstrates that a retired law enforcement officer who was previously qualified under the Law Enforcement Officers Safety Act, LEOSA, in California, is now residing in Arizona and wishes to carry a concealed firearm. Considering the federal nature of LEOSA and its interaction with state regulations, what is the most prudent course of action for the officer to ensure continued lawful concealed carry in Arizona? Option A. Proactively verify their current LEOSA eligibility and documentation requirements with the Arizona Department of Public Safety. Option B. Rely on informal advice from a former colleague in Arizona regarding their LEOSA status. Option C. Assume their California LEOSA qualification automatically and indefinitely allows them to carry in Arizona without further action. Option D. Believe that LEOSA status is a one-time qualification that never needs renewal or re-verification. The correct answer is A. Proactively verify their current LEOSA eligibility and documentation requirements with the Arizona Department of Public Safety. Explanation. The investigation demonstrates a scenario where a retired law enforcement officer, who previously qualified under the Law Enforcement Officers Safety Act, LEOSA, in California, is now seeking to carry a concealed firearm in Arizona. The professional challenge lies in ensuring compliance with the specific requirements of LEOSA as it applies across different states, particularly concerning the renewal and recognition of qualifications. LEOSA is a federal law, but its implementation and the recognition of qualifications can involve state-specific nuances and interpretations, necessitating a thorough understanding of both federal mandates and any relevant state administrative procedures. Careful judgment is required to avoid misinterpreting the scope of federal preemption and to ensure the officer's continued lawful carrying of a concealed firearm. The best approach involves the retired officer proactively verifying their current LEOSA eligibility with the Arizona Department of Public Safety. This is correct because LEOSA requires that an individual be separately qualified with a firearm. While federal law generally preempts state laws that would prohibit a qualified retired law enforcement officer from carrying a concealed firearm, the qualification itself must be current and recognized. Arizona, like other states, has administrative procedures for verifying, and in some cases, issuing identification that confirms LEOSA eligibility for retired officers residing or carrying in the state. Proactively contacting the relevant state agency ensures that the officer's previous qualification from California is understood within the context of Arizona's administrative framework, confirming that their status is recognized and that they possess the necessary documentation or have met any state-specific renewal or verification requirements. This aligns with the spirit of LEOSA, which aims to allow qualified officers to carry, but also acknowledges the need for clear and verifiable proof of qualification. An incorrect approach would be for the officer to assume their California qualification automatically and indefinitely allows them to carry in Arizona without any further action. This fails to recognize that, while LEOSA is federal, the practical administration and verification of qualification status can involve state-level processes. LEOSA requires an individual to be separately qualified and to carry identification. Relying solely on a past qualification without confirming its current validity and recognition in the new state of residence or operation could lead to a violation if Arizona has specific requirements for retired officers to maintain or re-verify their LEOSA status. Another incorrect approach would be for the officer to rely on informal advice from a former colleague in Arizona regarding their LEOSA status. While well-intentioned, this bypasses the official channels for verification and could lead to misinformation. LEOSA compliance is a legal matter, and relying on informal advice rather than consulting the official state agency responsible for firearms regulation and LEOSA verification is a significant regulatory failure. It does not provide the necessary assurance of compliance and could result in an officer unknowingly carrying a firearm unlawfully. A final incorrect approach would be for the officer to believe that LEOSA status is a one-time qualification that never needs renewal or re-verification. LEOSA itself does not mandate a specific renewal period for the underlying qualification, but it does require the individual to be separately qualified. Many retired officers maintain their qualification through annual or periodic training and requalification with a firearm, often as a practical necessity to ensure they remain proficient and to satisfy the spirit of the law. Assuming perpetual validity without any form of ongoing verification or practical requalification, especially when moving to a new jurisdiction, risks falling out of compliance if the underlying qualification is deemed to have lapsed, or if the new state has specific administrative expectations for retired officers. The professional reasoning process for such situations involves a multi-step approach. First, identify the governing federal law, LEOSA. Second, research the specific implementation and administrative requirements of that law in the relevant state, Arizona. Third, proactively contact the designated state agency for clarification and verification. Fourth, obtain and maintain all required documentation. Finally, remain informed about any changes in federal or state law that may affect eligibility. Question 6. Analysis of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification process in California requires a deep understanding of how federal mandates are integrated with state-specific regulations. Considering the potential for varied interpretations and implementation, what is the most prudent approach for a California law enforcement agency to ensure its officers are properly qualified to carry a concealed firearm under LEOSA? Option A. Conduct a thorough review of the California Penal Code sections that implement LEOSA, focusing on the specific requirements for firearm qualification and the designated certifying officials within the state. Option B. Rely solely on the federal LEOSA statute, assuming its provisions are universally applied without the need for state-specific verification. Option C. Accept any firearm qualification conducted by a federal agency, regardless of whether it aligns with California's specific training and documentation standards. Option D. Assume that a qualification conducted by any certified firearms instructor, even if not specifically authorized or adhering to California's LEOSA implementation, is sufficient. Correct answer is A. Conduct a thorough review of the California Penal Code sections that implement LEOSA, focusing on the specific requirements for firearm qualification and the designated certifying officials within the state. Explanation. Scenario analysis. This scenario presents a professional challenge due to the critical nature of ensuring compliance with the Federal Law Enforcement Officers Safety Act, LEOSA, in a state-specific context, specifically California. The challenge lies in navigating the nuances of state-level interpretations and implementation of a federal law, which can impact an officer's ability to carry a concealed firearm in the line of duty. Misinterpreting or failing to adhere to these specific requirements can have significant legal and professional repercussions for the officer and the agency. Careful judgment is required to balance federal mandates with state-specific regulations and to ensure the qualification process is both valid and legally sound. Correct approach analysis. The best professional practice involves a thorough review of the California Penal Code sections that implement LEOSA, specifically focusing on the requirements for firearm qualification and the designated certifying officials. This approach is correct because it directly addresses the legal framework governing LEOSA in California. By consulting the relevant statutes and understanding the specific training and certification standards mandated by the state, an agency can ensure its officers meet all necessary criteria. This proactive and legally grounded approach minimizes the risk of noncompliance and upholds the integrity of the LEOSA qualification process. Incorrect approaches analysis. One incorrect approach would be to solely rely on the federal LEOSA statute without considering California's specific implementation. This is professionally unacceptable because federal law often allows for state-level variations or additional requirements. California, like other states, has its own legislative framework that dictates how LEOSA is applied within its borders, including specific training protocols, and who is authorized to certify qualifications. Ignoring these state-specific mandates would render the qualification process potentially invalid under California law. Another incorrect approach would be to assume that a qualification conducted by a federal agency outside of California automatically satisfies California's LEOSA requirements. While federal qualification may be a component, California may have additional or different standards for its own officers or those seeking to carry within the state. This approach fails to recognize that LEOSA is a federal law that is implemented and enforced with state-specific considerations. A third incorrect approach would be to accept a firearm qualification that does not meet the specific standards outlined in California's Penal Code, even if the instructor is a certified firearms instructor. The key is not just the instructor's general certification, but their authority and adherence to the specific requirements for LEOSA qualification as defined by California law. This could include specific types of firearms, ammunition, or proficiency standards that must be met and documented in a manner prescribed by the state. Professional reasoning. Professionals should approach LEOSA qualification by first identifying the governing jurisdiction, in this case, California. They must then consult the specific state statutes and regulations that implement the federal LEOSA. This involves understanding who is authorized to certify qualifications, what specific training and proficiency standards must be met, and how these qualifications must be documented. A decision-making framework should prioritize legal compliance, thoroughness in documentation, and adherence to the most stringent requirements, federal and state, to ensure the validity of the qualification and the officer's ability to carry a concealed firearm legally. Question 7. Consider a scenario where a retired law enforcement officer from a California state agency seeks to obtain or have recognized a Law Enforcement Officers Safety Act, LEOSA, identification card. The officer states they retired with full pension benefits and were never convicted of a misdemeanor crime of domestic violence. What is the most appropriate course of action for the agency responsible for LEOSA qualification in the United States to ensure compliance with federal law? Option A. Accept the retired officer's self-attestation of eligibility without independent verification of their retirement status and the absence of disqualifying convictions. Option B. Deny the LEOSA qualification based solely on the fact that the officer retired from a state agency in California, without investigating whether that state agency's retirement policies align with the federal definition of full retirement benefits. Option C. Conduct a thorough review of the retired officer's documentation to verify their status as a qualified retired law enforcement officer by confirming separation from service in good standing, receipt of full retirement benefits, and absence of disqualifying convictions as defined by 18 U.S. Code Section 926C. Option D. Assume that any retired law enforcement officer is automatically qualified under LEOSA, regardless of the circumstances of their separation from service. The correct answer is C. Conduct a thorough review of the retired officer's documentation to verify their status as a qualified retired law enforcement officer by confirming separation from service in good standing, receipt of full retirement benefits, and absence of disqualifying convictions as defined by 18 U.S. Code Section 926C. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential for misinterpretation of the Law Enforcement Officers Safety Act, LEOSA, qualification requirements, and the critical need to uphold public safety and the integrity of law enforcement credentials. A retired officer's eligibility hinges on specific criteria, and any deviation or misunderstanding could lead to unauthorized carrying of a firearm, potentially endangering the public or undermining the LEOSA framework. The challenge lies in accurately assessing the retired officer's status against the federal statute, ensuring compliance without overreach or undue burden. Correct approach analysis. The best professional practice involves a thorough review of the retired officer's documentation to verify their compliance with all aspects of the Law Enforcement Officers Safety Act, LEOSA, as enacted in the United States. This includes confirming their status as a qualified retired law enforcement officer, as defined by 18 U.S. Code Section 926C, which mandates that they must have been separated from service in good standing, have separated from service with full retirement benefits, including a pension or annuity, and have not been convicted of a misdemeanor crime of domestic violence. The process requires diligent verification of the issuing agency's records and the retired officer's service history to ensure all statutory requirements are met before issuing or recognizing a LEOSA identification card. This approach directly adheres to the federal statute's intent and provisions, ensuring that only eligible individuals are authorized to carry firearms under LEOSA. Incorrect approaches analysis. One incorrect approach involves accepting the retired officer's self-attestation of eligibility without independent verification of their retirement status and the absence of disqualifying convictions. this fails to meet the due diligence required by LEOSA, which necessitates confirmation of separation from service with full retirement benefits and the absence of specific criminal conviction. Relying solely on the officer's word bypasses the statutory safeguards designed to prevent unauthorized firearm possession by individuals who may no longer meet the criteria. Another incorrect approach is to deny the LEOSA qualification based solely on the fact that the officer retired from a state agency in California, without investigating whether that state agency's retirement policies align with the federal definition of full retirement benefits as required by LEOSA. LEOSA is a federal law, and while state laws may govern the issuance of identification cards, the underlying eligibility criteria are federal. A blanket denial based on state of origin, without assessing the federal requirements, is a misapplication of the law. A further incorrect approach is to assume that any retired law enforcement officer is automatically qualified under LEOSA, regardless of the circumstances of their separation from service. LEOSA explicitly requires separation in good standing and with full retirement benefits. An officer who was terminated for cause or who did not qualify for pension or annuity payments would not meet these federal criteria, and assuming otherwise would be a significant regulatory failure. Professional reasoning. Professionals tasked with administering LEOSA qualifications should adopt a systematic approach. First, clearly understand the federal statutory requirements of 18 U.S. Code Section 926C. Second, establish a robust verification process that includes obtaining and reviewing official documentation from the retired officer's former agency, confirming their separation status, retirement benefits, and absence of disqualifying convictions. Third, consult with legal counsel if there is any ambiguity regarding the interpretation of good standing or full retirement benefits in specific contexts. Finally, maintain detailed records of all verifications and decisions to ensure transparency and accountability. This methodical process ensures compliance with federal law and upholds the safety and integrity of the LEOSA program. Question 8. During the evaluation of a retired law enforcement officer's eligibility to carry a concealed firearm under the Federal Law Enforcement Officers Safety Act, LEOSA, in Florida, what is the most prudent course of action to ensure full compliance with both federal and state regulations? Option A. Prioritize any perceived state-level restrictions in Florida over the explicit provisions of federal LEOSA, even if those state restrictions are not explicitly permitted by federal law to supersede LEOSA. Option B. Confirm the officer's status as a qualified retired law enforcement officer, QRLEO, and verify their completion of a firearms proficiency test that meets federal LEOSA standards, while also researching and confirming any specific Florida statutes or administrative rules that may apply to QRLEO carrying concealed firearms within the state. Option C. Assume that federal LEOSA provisions are the sole governing authority and that no additional state-level requirements in Florida need to be considered for retired officers. Option D. Rely exclusively on the officer's previous agency identification and a general understanding of LEOSA, without independently verifying their current proficiency or any specific state-level considerations in Florida. The correct answer is B. Confirm the officer's status as a qualified retired law enforcement officer, QRLEO, and verify their completion of a firearms proficiency test that meets federal LEOSA standards, while also researching and confirming any specific Florida statutes or administrative rules that may apply to QRLEO carrying concealed firearms within the state. Explanation. This scenario presents a professional challenge because it requires a law enforcement officer to navigate the nuances of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements, while also considering the specific state laws of Florida that may impose additional or differing stipulations. The core of the challenge lies in ensuring compliance with federal mandates while respecting state-level authority and preventing potential legal ramifications for both the officer and the employing agency. Careful judgment is required to avoid misinterpreting the scope of LEOSA and to ensure that any state-specific requirements do not unduly restrict the rights granted by federal law, or conversely, that federal law is not misapplied in a way that overrides legitimate state interests. The best professional approach involves a thorough understanding of both the federal LEOSA statute and Florida's specific legislative enactments, or interpretations related to concealed carry for retired law enforcement officers. This approach prioritizes verifying the officer's eligibility under the federal act, which includes confirming their status as a qualified retired law enforcement officer, QRLEO, and ensuring they meet the firearms proficiency requirements as outlined by federal law. Simultaneously, it necessitates confirming that Florida law does not impose any additional, permissible restrictions or procedural requirements on QRLEO seeking to carry concealed firearms within the state, such as specific notification or registration processes that are consistent with federal law. This ensures full compliance with all applicable legal frameworks, safeguarding the officer's rights and the agency's adherence to regulation. An incorrect approach would be to solely rely on the federal LEOSA qualification, without investigating any potential Florida-specific nuances. This could lead to a situation where the officer is federally compliant, but inadvertently violates a Florida statute, creating legal jeopardy. Another incorrect approach would be to assume that Florida law automatically mirrors federal LEOSA requirements without independent verification. This could result in the officer being denied the right to carry concealed if Florida has implemented specific, permissible state-level procedures that were overlooked. Finally, an approach that prioritizes state law over clear federal mandates, attempting to impose restrictions not permitted by LEOSA, would also be professionally unacceptable and legally flawed. Professionals should employ a decision-making framework that begins with identifying the governing federal law, LEOSA. This is followed by a diligent search for any state-specific legislation or administrative rules in Florida that pertain to retired law enforcement officer firearm carry. The next step is a comparative analysis to determine how state provisions interact with federal law, identifying any areas of potential conflict or additional requirements. The ultimate decision must be to adhere to the most stringent requirements that are legally permissible, ensuring both federal and state compliance. This systematic process prevents assumptions and ensures a robust understanding of all applicable legal obligations. Question 9. Research into the Federal Law Enforcement Officers Safety Act, LEOSA, qualification process in the United States has revealed a situation where a retired police officer from Texas, who has otherwise met all requirements, is seeking recertification. However, it has come to light that the officer received a formal written reprimand 2 years ago for minor procedural violation during an investigation, which did not involve any use of force or loss of firearm authority. Considering the specific provisions of 18 U.S. Code Section 926C and relevant Texas statutes, what is the most appropriate course of action regarding the officer's LEOSA qualification? Option A. Automatically deny the officer's qualification due to the existence of any disciplinary action on their record. Option B. Conduct a detailed review of the written reprimand to determine if it constitutes a disqualifying offense under federal or Texas law, and proceed with qualification if it does not. Option C. Deny qualification based on the principle that any disciplinary action, however minor, reflects poorly on an officer's suitability to carry a firearm. Option D. Rely on the officer's statement that the reprimand was minor and proceed with qualification without further investigation. Correct answer is B. Conduct a detailed review of the written reprimand to determine if it constitutes a disqualifying offense under federal or Texas law, and proceed with qualification if it does not. Explanation. Research into the nuances of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification process in the United States presents a professionally challenging scenario when a retired officer's eligibility is questioned due to a recent minor disciplinary action. The challenge lies in balancing the intent of LEOSA, which is to allow qualified retired officers to carry firearms, with the need to ensure public safety and uphold the integrity of law enforcement standards. Careful judgment is required to interpret the statute and relevant state-level interpretations, which can vary. The best professional approach involves a thorough review of the specific disciplinary action and its classification under LEOSA disqualifying offenses. This requires consulting the exact language of 18 U.S. Code Section 926C and any applicable state statutes or administrative rules that further define disqualifications. The focus should be on whether the disciplinary action constitutes a misdemeanor crime of domestic violence or a conviction for a felony, or if it resulted in the revocation of the officer's authority to carry a firearm. If the disciplinary action, despite being minor, falls into a disqualifying category as defined by federal or state law, then the officer is indeed ineligible. This approach prioritizes strict adherence to the legal framework governing LEOSA qualification, ensuring that only those who meet all statutory requirements are certified. An incorrect approach would be to assume that any disciplinary action, regardless of its nature or classification, automatically disqualifies an officer. This fails to recognize that LEOSA specifically enumerates disqualifying offenses. A minor infraction, such as a procedural error that did not involve violence or a loss of firearm authority, may not meet the statutory criteria for disqualification. Another incorrect approach is to rely solely on the officer's personal assertion of eligibility without independent verification of the disciplinary action's impact on their LEOSA status. This bypasses the due diligence required to ensure compliance with federal and state law. Finally, an approach that prioritizes convenience or a desire to avoid conflict by overlooking potential disqualifications would be professionally unacceptable, as it compromises public safety and the integrity of the LEOSA program. Professionals should employ a systematic decision-making process. First, identify the specific federal and state laws governing LEOSA qualification and disqualifications. Second, obtain all relevant documentation pertaining to the retired officer's service record and any disciplinary actions. Third, meticulously compare the nature and outcome of any disciplinary actions against the explicit disqualifying criteria outlined in the law. If ambiguity exists, seek clarification from the relevant state or federal agency responsible for LEOSA certifications. Question 10. Governance review demonstrates that a retired law enforcement officer in California is seeking to requalify for LEOSA privileges. The officer's agency of retirement requires an annual firearms proficiency qualification that includes a minimum of 16 hours of documented training. The officer has provided records showing 12 hours of firearms training completed within the current calendar year. Based on the Federal Law Enforcement Officers Safety Act, LEOSA, and its implications for California, what is the minimum additional number of training hours the officer must complete to meet the annual requirement? Option A, 16 hours. Option B, 2 hours. Option C, 0 hours. Option D, 4 hours. The correct answer is D, 4 hours. Explanation. Governance review demonstrates that ensuring compliance with the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements in California involves meticulous record-keeping and adherence to specific training protocols. This scenario is professionally challenging because it requires a precise understanding of the LEOSA statute, as amended by subsequent legislation, and its intersection with California's specific firearms and training regulations for retired law enforcement officers. Misinterpreting these requirements can lead to an officer being improperly certified, potentially facing legal repercussions, and compromising public safety. The core of the challenge lies in accurately calculating the required training hours and ensuring the firearms used meet the statutory definition. The best approach involves a direct calculation based on the statutory minimums and the officer's documented training history. This approach correctly identifies that LEOSA, as codified in 18 U.S. Code Section 926C, requires a qualified retired law enforcement officer to have completed a firearms proficiency test that is approved by the agency from which the officer retired or by the state in which the officer resides. In California, this often translates to specific training course requirements. If the statute mandates a minimum of 16 hours of firearms training annually, and the officer has completed 12 hours in the current year, the calculation is straightforward. 16 hours required, 12 hours completed, equals 4 hours additional training needed. This method directly addresses the numerical deficit and ensures compliance with the spirit and letter of the law by meeting the minimum annual training requirement. An incorrect approach would be to assume that any firearms training, regardless of its duration or specific content, satisfies the LEOSA requirement. This fails to acknowledge the statutory mandate for a firearms proficiency test, which implies a structured and measurable assessment, not just informal practice. Another incorrect approach is to solely rely on the officer's self-reported completion of training without verifying the actual hours and curriculum against LEOSA standards and California's specific implementation guidelines. This bypasses the necessary due diligence and could lead to a false sense of compliance. Finally, an approach that prioritizes convenience over statutory compliance, such as accepting a shorter, non-standardized training course, directly violates the LEOSA requirements for a recognized proficiency test and the underlying principle of ensuring officers remain competent and safe. Professionals should employ a decision-making framework that begins with a thorough understanding of the relevant federal statute, LEOSA, and any applicable state-specific regulations or guidance, in this case, California's interpretation and implementation. This involves consulting official documentation, seeking clarification from relevant authorities if necessary, and performing precise calculations based on documented evidence of training. The process should always prioritize statutory compliance and public safety over expediency. Question 11. Market research demonstrates that retired law enforcement officers in California are increasingly seeking to understand and maintain their eligibility for carrying firearms under the Federal Law Enforcement Officers Safety Act, LEOSA. Considering the interplay between federal law and California's specific regulatory environment, which of the following actions represents the most prudent and compliant approach for a retired California peace officer to ensure their continued LEOSA qualification? Option A. Seek firearm qualification from any instructor who claims to be familiar with firearms, regardless of their specific LEOSA certification or adherence to federal qualification standards. Option B. Proactively verify eligibility and qualification requirements with their former agency or a LEOSA-qualified instructor to confirm current status and necessary steps for maintaining qualification under federal and California guidelines. Option C. Rely on personal interpretations of LEOSA gleaned from online forums and anecdotal evidence to determine their qualification status and carrying rights. Option D. Assume that their federal retirement status as a law enforcement officer automatically permits them to carry a firearm under LEOSA without any further action or verification. The correct answer is B. Proactively verify eligibility and qualification requirements with their former agency or a LEOSA-qualified instructor to confirm current status and necessary steps for maintaining qualification under federal and California guidelines. Explanation. Market research demonstrates that a significant number of retired law enforcement officers in California are seeking to maintain their firearm proficiency and understand their rights under the Law Enforcement Officers Safety Act, LEOSA. This scenario presents a professional challenge because it requires a nuanced understanding of LEOSA federal provisions as applied within California's specific state laws and regulations concerning firearms. Misinterpreting these requirements can lead to legal complications for both the retired officer and the entity providing qualification services. Careful judgment is required to ensure compliance and uphold the spirit of LEOSA while respecting California's regulatory landscape. The best approach involves a retired law enforcement officer in California proactively verifying their eligibility and understanding the specific qualification requirements mandated by LEOSA, which includes consulting with their former agency or a LEOSA-qualified instructor to confirm their status and the necessary steps for maintaining their qualification. This is correct because LEOSA is a federal law, but its implementation and recognition can be influenced by state laws and agency policies. By engaging with their former agency or a qualified instructor, the officer ensures they are adhering to the most current and accurate interpretation of LEOSA as it applies to their situation in California, including any specific state-level requirements or nuances that might affect their ability to carry. This proactive verification is the most responsible and legally sound method to ensure continued compliance. An incorrect approach would be for the retired officer to assume their federal retirement status automatically grants them the right to carry under LEOSA without any further action or verification, relying solely on their past service. This is professionally unacceptable because, while LEOSA provides a federal right, it is not self-executing without meeting specific qualification criteria and potentially agency-specific procedures. Another incorrect approach would be for the officer to seek qualification from an instructor who is not certified or recognized under LEOSA or California law, or who provides a qualification that does not meet the federal standards. This is professionally unacceptable as it bypasses the established safety and competency requirements of LEOSA, potentially rendering the qualification invalid and exposing the officer to legal risks. Finally, an incorrect approach would be for the officer to rely on outdated information or personal interpretations of LEOSA without confirming current regulations and agency policies. This is professionally unacceptable because laws and regulations can change, and relying on outdated or unverified information can lead to non-compliance. Professionals should approach LEOSA qualification by prioritizing verification and adherence to established federal and state guidelines. This involves understanding that LEOSA is a federal law with specific requirements, but its practical application may involve state-specific considerations and agency policies. A robust decision-making process includes consulting official sources, qualified instructors, and relevant agencies to ensure all criteria are met. Question 12. The control framework reveals that a former police officer in Texas, who served for 25 years with a clean record but retired due to a departmental restructuring that eliminated their position, is seeking to qualify for firearm carry under the Federal Law Enforcement Officers Safety Act, LEOSA. The officer has not carried a firearm since their retirement 2 years ago and has not undergone any LEOSA-specific firearms qualification since that time. Considering the nuances of LEOSA eligibility, which of the following represents the most appropriate course of action to determine the officer's qualification? Option A. Assume the officer is qualified for LEOSA carry based on their 25 years of service and clean record. As departmental restructuring is a common reason for retirement. Option B. Recommend the officer obtain a new firearms proficiency certification from their former department, if possible, and then proceed with LEOSA qualification, as the 2-year gap in carrying may require re-establishment of proficiency. Option C. Advise the officer that they are automatically qualified under LEOSA due to their lengthy service and former status as a law enforcement officer, and suggest they find a local firearms instructor for a standard concealed carry qualification. Option D. Verify the officer's complete service record to confirm they meet the statutory definition of a qualified retired law enforcement officer, including continuous service and separation from service other than by reason of mental inconsistency, and ensure they are not otherwise prohibited from possessing a firearm under federal law. The correct answer is D. Verify the officer's complete service record to confirm they meet the statutory definition of a qualified retired law enforcement officer, including continuous service and separation from service other than by reason of mental inconsistency, and ensure they are not otherwise prohibited from possessing a firearm under federal law. Explanation. The control framework reveals that the Federal Law Enforcement Officers Safety Act, LEOSA, in the United States is designed to allow qualified former law enforcement officers to carry firearms. The scenario presents a challenge because it requires understanding the nuances of LEOSA qualification requirements and how they apply to an individual who may have retired under specific circumstances. The core of the challenge lies in discerning whether the officer's retirement status and subsequent actions align with the federal statute's intent and specific provisions, particularly concerning continuous service and the definition of qualified. The best professional approach involves a thorough review of the officer's service record and the specific criteria outlined in the LEOSA statute and its implementing regulations. This includes verifying that the officer meets the definition of a qualified retired law enforcement officer, as defined by federal law, which typically requires continuous service for a specified period, separation from service other than by reason of mental inconsistency, and not being prohibited by federal law from possessing a firearm. This approach ensures compliance with the letter and spirit of the law, prioritizing accurate assessment over assumptions. An incorrect approach would be to assume that any former law enforcement officer is automatically eligible for LEOSA qualification simply by virtue of their past service. This fails to acknowledge the statutory requirements for continuous service and the specific conditions under which an officer may be prohibited from carrying a firearm, such as disciplinary actions or mental health evaluations that could disqualify them. Another incorrect approach is to rely solely on the officer's self-declaration of eligibility without independent verification of their service record and adherence to LEOSA-specific criteria. This bypasses due diligence and could lead to an individual who is not legally authorized to carry a firearm doing so, creating a significant legal and public safety risk. A further flawed approach is to interpret LEOSA as a blanket right to carry for all former officers, ignoring the detailed qualification and disqualification provisions within the statute. Professionals should approach such situations by first understanding the specific legal framework, LEOSA in this case, and its definitions. They must then gather all relevant documentation pertaining to the individual's service history and separation from service. A systematic comparison of this information against the statutory requirements is crucial. If any ambiguities or potential disqualifications arise, further investigation or consultation with legal counsel specializing in firearms law and LEOSA is warranted before making a determination. This methodical, evidence-based process ensures adherence to legal mandates and upholds public safety. Question 13. A retired Texas peace officer who served for 15 years before retiring due to a service-connected disability presents a valid Texas Retired Peace Officer Identification Card and a recent firearms qualification certificate issued by a private security firm to a Texas state trooper during a routine traffic stop. The retired officer states they are carrying a concealed handgun under the authority of the Law Enforcement Officers Safety Act, LEOSA. What is the most appropriate course of action for the state trooper? Option A. Immediately allow the retired officer to proceed without further inquiry, as the presentation of a retired peace officer identification card is sufficient proof of LEOSA eligibility. Option B. Detain the retired officer and confiscate their firearm pending a full investigation into their LEOSA eligibility, as the circumstances of their retirement due to disability raise immediate concerns. Option C. Accept the firearms qualification certificate from the private security firm at face value, as LEOSA allows for qualification by any entity that deems the officer proficient. Option D. Verify the retired officer's eligibility under LEOSA by confirming their service history, the nature of their separation from service, and the validity of their identification and firearms qualification according to both federal LEOSA requirements and Texas state law, including whether the issuing entity for the qualification is recognized. The correct answer is D. Verify the retired officer's eligibility under LEOSA by confirming their service history, the nature of their separation from service, and the validity of their identification and firearms qualification according to both federal LEOSA requirements and Texas state law, including whether the issuing entity for the qualification is recognized. Explanation. Market research demonstrates that understanding the nuances of the Law Enforcement Officers Safety Act, LEOSA, qualification process is crucial for maintaining compliance and ensuring the safety of qualified individuals. This scenario presents a professional challenge because it requires a law enforcement agency to balance the statutory rights of retired officers to carry concealed firearms under LEOSA with the agency's responsibility to ensure that all individuals carrying firearms within its jurisdiction are properly qualified and pose no undue risk. The challenge lies in interpreting the specific requirements of LEOSA, particularly concerning the definition of qualified retired law enforcement officer and the acceptable methods of qualification, while also adhering to state-specific regulations in Texas that may further define these parameters. The best professional approach involves a thorough review of the retired officer's documentation to confirm they meet all federal LEOSA criteria and any supplementary requirements established by Texas law or the agency's internal policies. This includes verifying that the retired officer is carrying a photographic identification issued by the former employer that identifies the person as a law enforcement officer, or indicating that the individual has been separated from service after completing a minimum of 10 years of service, or separated from service due to a service-connected disability, and is not prohibited by federal law from possessing a firearm. Crucially, it also necessitates confirming that the retired officer has been deemed qualified by their former agency to carry a firearm, as per LEOSA requirements, which often involves periodic firearms proficiency testing. This approach is correct because it directly aligns with the intent of LEOSA, which is to allow qualified retired officers to carry firearms, while simultaneously ensuring that the agency upholds its duty to public safety by verifying eligibility and qualification according to established legal frameworks. An incorrect approach would be to assume that simply possessing a retired law enforcement identification card automatically grants the right to carry a concealed firearm without further verification of current qualification status. This fails to acknowledge that LEOSA requires ongoing qualification, and Texas law may impose additional stipulations. Another incorrect approach would be to deny the retired officer the right to carry based solely on their retired status without examining their specific LEOSA eligibility and qualification documentation. This would contravene the federal statute. Finally, accepting a qualification certificate from an entity not recognized by either federal LEOSA guidelines or Texas state law as a valid instructor or agency for qualification purposes would be a significant regulatory failure, as it would not meet the established standards for demonstrating firearms proficiency. Professionals should employ a decision-making framework that prioritizes a meticulous review of all relevant documentation against the specific requirements of federal LEOSA and applicable state laws in Texas. This involves understanding the definitions of qualified retired law enforcement officer, the acceptable forms of identification, and the mandated qualification standards. When faced with ambiguity, consulting with legal counsel or the relevant state regulatory bodies is essential to ensure adherence to the law and to maintain public trust. Question 14. Which approach would be most prudent for a retired federal law enforcement officer in Florida seeking to ensure their compliance with the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements when their previous qualification expired 6 months ago and they are preparing for a new qualification session? Option A. Assume that their federal law enforcement status and expired qualification from another state are sufficient for carrying in Florida under LEOSA. Option B. Attempt to use their previous expired qualification as proof of current status until a new one can be obtained, believing federal law provides immediate carry rights. Option C. Rely solely on their understanding of the federal LEOSA statute without investigating Florida's specific administrative procedures for qualification. Option D. Contact the Florida Department of Law Enforcement, FDLE, to confirm the specific documentation and procedural requirements for LEOSA qualification in Florida and schedule the qualification session accordingly. The correct answer is D. Contact the Florida Department of Law Enforcement, FDLE, to confirm the specific documentation and procedural requirements for LEOSA qualification in Florida and schedule the qualification session accordingly. Explanation. This scenario is professionally challenging because it requires a law enforcement officer to navigate the nuances of the Federal Law Enforcement Officers Safety Act, LEOSA, qualification requirements, while operating in a state with specific interpretations or administrative procedures that may not be immediately obvious. The officer must ensure their actions are compliant with federal law, while respecting any state-level administrative processes that facilitate or govern the exercise of LEOSA rights. The core challenge lies in balancing the federal right to carry with the state's administrative framework for demonstrating that right. The best approach involves proactively seeking clarification and ensuring all necessary documentation is in order according to both federal mandates and the specific administrative requirements of the state where the qualification is to occur. This means understanding that while LEOSA grants the right to carry, the qualification process is often administered at the state level, and adherence to those specific procedures is crucial for lawful compliance. This approach is correct because it prioritizes full compliance with the spirit and letter of LEOSA, while also respecting the administrative mechanisms put in place by the state of Florida to verify and document such qualifications. It demonstrates a commitment to due diligence and avoids potential misunderstandings or challenges to the officer's status. An approach that assumes federal law supersedes all state administrative processes without verifying those processes is incorrect. Its failure to acknowledge or engage with Florida's specific administrative requirements for LEOSA qualification could lead to the officer being unable to demonstrate their lawful authority to carry, potentially resulting in a violation or misunderstanding with local authorities. Another incorrect approach is to rely solely on a previous qualification from another state without confirming its validity or transferability under Florida's specific rules. LEOSA qualifications are often state-specific in their administration, and a qualification valid in one state may not automatically satisfy the requirements in another. Finally, an approach that attempts to bypass or expedite the qualification process without proper documentation or verification, based on the officer's federal authority alone, risks misinterpretation and noncompliance with the state's established procedures for LEOSA. Professionals should employ a decision-making framework that begins with understanding the federal law LEOSA, then thoroughly researching and understanding the specific implementation and administrative requirements of the relevant state, Florida in this case. And finally, proactively engaging with the appropriate state authorities or designated entities to ensure all qualification and documentation requirements are met before attempting to exercise the right to carry under LEOSA. Question 15. Investigation of a retired Texas law enforcement officer's eligibility for concealed carry under the Federal Law Enforcement Officers Safety Act, LEOSA, has revealed a potential issue with their firearms proficiency qualification. The retired officer obtained their qualification from an individual who holds a general handgun instructor certification issued by a national organization. This instructor has no specific affiliation with any Texas law enforcement agency and has not undergone any specific training or certification related to LEOSA qualification requirements. What is the most appropriate course of action to ensure the retired officer's LEOSA status is valid under Texas regulations? Option A. Accept the qualification as valid, assuming that a general handgun instructor certification is sufficient for LEOSA purposes in Texas. Given the instructor's experience, Option B. Contact the Texas Department of Public Safety, DPS, and the retired officer's former employing agency to ascertain their specific requirements for LEOSA qualification instructors and confirm if the instructor meets those criteria. Option C. Advise the retired officer to seek a new qualification from an instructor who claims to be experienced with LEOSA without verifying their official standing with Texas authorities. Option D. Proceed with the assumption that the instructor's national certification automatically satisfies LEOSA requirements in Texas, as LEOSA is a federal law. The correct answer is B. Contact the Texas Department of Public Safety, DPS, and the retired officer's former employing agency to ascertain their specific requirements for LEOSA qualification instructors and confirm if the instructor meets those criteria. Explanation. This scenario presents a professional challenge due to the nuanced interpretation of qualified handgun instructor under the Federal Law Enforcement Officers Safety Act, LEOSA, and its application within the state of Texas. LEOSA, codified at 18 U.S.C. Section 926C, allows certain qualified retired law enforcement officers to carry concealed firearms. A critical component of LEOSA is the requirement for these officers to meet a firearms proficiency standard, often established by their former agency or a state-certified instructor. The challenge lies in determining if an individual who has completed a general firearms instructor course without specific LEOSA qualification experience or a clear endorsement from a Texas law enforcement agency for LEOSA purposes meets the qualified handgun instructor standard for the purpose of certifying a retired officer's proficiency. The best approach involves seeking direct clarification from the Texas Department of Public Safety, DPS, or the retired officer's former employing agency regarding their specific requirements for LEOSA qualification instructors. This is the correct approach because LEOSA implementation often relies on state-level interpretations and agency-specific policies. The Texas DPS, as the state authority responsible for firearms licensing and regulation, is best positioned to provide definitive guidance on what constitutes a qualified handgun instructor for LEOSA purposes within Texas. Furthermore, consulting the retired officer's former agency ensures adherence to any internal policies or specific training mandates they may have for their retirees seeking LEOSA certification. This proactive and authoritative consultation minimizes the risk of noncompliance and ensures the retired officer's LEOSA status is valid. An incorrect approach would be to assume that any individual holding a general firearms instructor certification is automatically qualified to certify LEOSA proficiency. This is problematic because LEOSA proficiency requirements are often more stringent than general civilian instructor standards and may require specific knowledge of law enforcement protocols or agency-specific training methodologies. Relying solely on a general certification without verifying its LEOSA applicability in Texas could lead to the retired officer being improperly certified and potentially facing legal repercussions. Another incorrect approach is to proceed with the qualification based solely on the instructor's personal belief that their general certification is sufficient. This demonstrates a lack of due diligence and a failure to adhere to the spirit and letter of LEOSA, which emphasizes verifiable proficiency standards. Professional ethics demand that individuals responsible for certifying LEOSA qualifications act with certainty and clarity, not on personal assumptions, especially when the legal status and rights of a retired law enforcement officer are at stake. Finally, an incorrect approach would be to accept a qualification from an instructor who is not recognized by the Texas DPS or the retired officer's former agency, even if they possess a seemingly relevant certification. This ignores the established regulatory pathways and oversight mechanisms designed to ensure the integrity of LEOSA qualifications. The professional decision-making process for similar situations should involve 1. Identifying the specific regulatory framework, LEOSA, and its jurisdictional application, Texas. 2. Recognizing the critical element requiring interpretation, qualified handgun instructor. 3. Prioritizing consultation with the relevant state regulatory bodies, Texas DPS, and the retired officer's former employing agency. 4. Documenting all communications and decisions made based on official guidance. 5. Acting with a commitment to compliance and the integrity of the LEOSA program. Question 16. Assessment of a retired law enforcement officer's eligibility for concealed carry privileges under the Law Enforcement Officers Safety Act, LEOSA, in Kansas, requires careful consideration of specific state statutes. If a retired officer from the Kansas Highway Patrol, who separated from service under honorable conditions and has no disqualifying criminal history, applies for LEOSA qualification, what is the most appropriate course of action for the issuing authority? Option A. Grant the application without further verification, assuming that honorable separation is implied by the officer's past service and that no additional checks are necessary. Option B. Conduct a comprehensive review of the officer's service record and documentation to ensure compliance with all eligibility requirements as defined by Kansas LEOSA statutes, including honorable separation and absence of disqualifying offenses. Option C. Issue a provisional LEOSA qualification, pending a review of the officer's current personal circumstances and any informal assessments of their character by community members. Option D. Deny the application based on the officer no longer being actively employed by a Kansas law enforcement agency, as this is perceived as the primary criterion for LEOSA eligibility. The correct answer is B. Conduct a comprehensive review of the officer's service record and documentation to ensure compliance with all eligibility requirements as defined by Kansas LEOSA statutes, including honorable separation and absence of disqualifying offenses. Explanation. This scenario presents a professional challenge due to the nuanced interpretation and application of the Law Enforcement Officers Safety Act, LEOSA, in a state-specific context, particularly when dealing with retired officers whose circumstances may have changed since their law enforcement service. The core difficulty lies in ensuring compliance with the Act's provisions while respecting the rights of qualified individuals. Careful judgment is required to avoid both overreach in denying LEOSA privileges and underreach in failing to uphold the Act's limitations. The best professional approach involves a thorough review of the retired officer's documentation against the specific requirements of the Kansas LEOSA statute, including verification of their status as a qualified retired law enforcement officer, as defined by Kansas law. This includes confirming their separation from service under honorable conditions and ensuring they have not been found guilty of a misdemeanor crime of domestic violence. This approach is correct because it directly adheres to the statutory framework established by Kansas for LEOSA qualification, prioritizing legal compliance and accurate verification of eligibility criteria. It demonstrates a commitment to upholding the law as written and applied within the state. An incorrect approach would be to deny LEOSA qualification solely based on the officer's age, or the fact that they are no longer actively employed by a Kansas law enforcement agency, without a deeper examination of the specific statutory definitions and exceptions within Kansas law. This is professionally unacceptable because it misinterprets the scope of LEOSA, which explicitly includes retired officers who meet certain criteria, and it fails to acknowledge that separation from service does not automatically disqualify an individual if other conditions are met. Another incorrect approach would be to grant LEOSA qualification without verifying the officer's separation from service was honorable. This is professionally unacceptable as it bypasses a critical eligibility requirement stipulated by LEOSA and potentially by Kansas's specific implementation of the Act. An honorable separation is a fundamental condition for LEOSA privileges, and failing to verify this opens the door to potential noncompliance and misuse of the Act. Finally, an incorrect approach would be to rely on informal understandings or personal opinions about the officer's character rather than the objective criteria outlined in the Kansas statutes. This is professionally unacceptable because it introduces subjectivity and bias into a process that must be governed by clear, verifiable legal standards. LEOSA qualification is a legal right contingent upon meeting specific statutory requirements, not on personal endorsements or assumptions. A professional reasoning process for similar situations should involve a systematic review of all relevant statutes and regulations pertaining to LEOSA in the specific jurisdiction, in this case, Kansas. This includes consulting official guidance from the relevant state agencies. When presented with an application, one should meticulously check each eligibility criterion against the provided documentation. If any ambiguity exists, seeking clarification from legal counsel or the relevant state authority is paramount. The decision-making framework should prioritize adherence to the letter and spirit of the law, ensuring fairness and due process for all applicants while maintaining public safety. Question 17. A former police officer in Texas who retired from a state agency last year after 25 years of service under honorable conditions seeks to obtain a LEOSA qualification. The officer has not carried a firearm in an official capacity since retirement, but has maintained personal proficiency. The agency's firearms instructor is unsure if the officer's current status automatically qualifies them under the Federal Law Enforcement Officers Safety Act, as implemented in Texas, given the change from active duty to retired status and the lack of recent official carry. What is the most appropriate course of action for the firearms instructor to ensure compliance with LEOSA regulations in Texas? Option A. Rely on the officer's self-assessment of their personal firearms proficiency as meeting the requirements for LEOSA qualification in Texas. Option B. Verify the officer's retirement status, confirm it was under honorable conditions, and ascertain if they have completed a firearms proficiency course as required by Texas law for retired officers within the specified time frame. Option C. Advise the officer that since they are no longer actively carrying a firearm in an official capacity, they are ineligible for LEOSA qualification, regardless of their retirement status. Option D. Grant the LEOSA qualification based on the officer's 25 years of service and honorable retirement, assuming their past experience is sufficient. The correct answer is B. Verify the officer's retirement status, confirm it was under honorable conditions, and ascertain if they have completed a firearms proficiency course as required by Texas law for retired officers within the specified time frame. Explanation. Market research demonstrates that understanding the nuances of the Law Enforcement Officers Safety Act, LEOSA, qualification process is crucial for ensuring compliance and maintaining public trust. This scenario presents a professional challenge because it involves a potential misinterpretation of LEOSA eligibility based on a change in employment status, which could lead to an officer being improperly denied or granted a qualification. Careful judgment is required to navigate the specific requirements of the Act and its implementing regulations in the state of Texas. The best professional approach involves a thorough review of the officer's current employment status and the specific criteria outlined in Texas statutes and federal LEOSA regulations concerning retired law enforcement officers. This includes verifying if the officer's separation from service was under honorable conditions, and if they meet the ongoing requirements for maintaining LEOSA eligibility, such as periodic firearms proficiency. This approach is correct because it directly addresses the core of the LEOSA qualification by adhering strictly to the statutory definitions and requirements for both active and retired officers as interpreted and implemented within Texas law, ensuring that the qualification is granted only if all legal prerequisites are met. An incorrect approach would be to assume that any officer who previously carried a firearm in an official capacity is automatically eligible for LEOSA qualification upon retirement, without verifying the specifics of their retirement status and adherence to ongoing requirements. This fails to acknowledge that LEOSA eligibility for retired officers is conditional and requires specific verification of honorable separation, and in many states including Texas, periodic firearms proficiency. Another incorrect approach would be to rely solely on the officer's self-declaration of eligibility without independent verification of their status and adherence to the Texas requirements for retired officers, such as proof of completion of a firearms proficiency course within a specified time frame. This bypasses the necessary due diligence mandated by the Act and state implementation. A further incorrect approach would be to grant the qualification based on a perceived past performance or reputation, disregarding the formal, documented requirements of LEOSA and Texas law. This prioritizes informal considerations over the legal framework, creating a compliance risk. Professionals should employ a decision-making framework that prioritizes adherence to the letter of the law and relevant regulations. This involves 1. Identifying the specific legal framework governing the situation, LEOSA and Texas statutes. 2. Gathering all relevant facts about the individual's status. 3. Comparing the facts against the legal requirements. 4. Seeking clarification from appropriate legal counsel or regulatory bodies if ambiguity exists. 5. Making a decision based solely on the established legal criteria, ensuring fairness and compliance. Question 18. Risk assessment procedures indicate that a federal law enforcement officer, qualified under the Law Enforcement Officers Safety Act, LEOSA, in the state of California, is carrying a concealed firearm while attending a private event at a restaurant that has a posted no firearms policy. Which of the following actions best represent the officer's professional and legally compliant response? Option A. The officer proceeds with their concealed firearm without informing anyone, relying solely on their LEOSA rights. Option B. The officer discreetly informs the restaurant's management or security personnel about their LEOSA-qualified status and concealed firearm. Option C. The officer immediately leaves the restaurant upon noticing the no firearms policy without any attempt at communication. Option D. The officer openly displays their badge and firearm to announce their LEOSA status to patrons and staff. Correct answer is B. The officer discreetly informs the restaurant's management or security personnel about their LEOSA-qualified status and concealed firearm. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between an officer's statutory right to carry a concealed firearm under the Law Enforcement Officers Safety Act, LEOSA, and the potential for public safety concerns arising from the presence of a firearm in a sensitive location. The officer must navigate their legal entitlement with a duty to act responsibly and consider the environment. Careful judgment is required to balance personal safety rights with the broader responsibility to avoid unnecessary alarm or potential escalation. Correct approach analysis. The best professional practice involves the officer proactively and discreetly informing the relevant security personnel or management of the establishment about their status as a LEOSA-qualified individual carrying a concealed firearm. This approach is correct because it upholds the officer's LEOSA rights while prioritizing transparency and de-escalation. By informing security, the officer demonstrates respect for the establishment's policies and allows for a coordinated understanding of the situation, thereby mitigating potential misunderstandings or unnecessary alarm among other patrons or staff. This proactive communication aligns with ethical principles of responsible firearm carriage and community safety. Incorrect approaches analysis. One incorrect approach is for the officer to remain silent and concealed, assuming their LEOSA status grants them unfettered access and that no disclosure is necessary. This fails to acknowledge the potential for public perception and the establishment's right to manage its premises. It can lead to alarm if the firearm is discovered inadvertently or if the officer is perceived as a threat, potentially triggering a response from security or law enforcement that could have been avoided through simple communication. This approach disregards the ethical consideration of minimizing public apprehension. Another incorrect approach is for the officer to openly display their firearm or badge to announce their LEOSA status. While this might assert their rights, it is an unnecessarily confrontational and potentially alarming action. It can create undue fear and panic among the public, undermining the very safety the LEOSA is intended to support. This approach fails to consider the impact on the environment and the principle of responsible, discreet firearm carriage. A further incorrect approach is for the officer to immediately leave the establishment upon encountering a no firearms policy without attempting any communication. While respecting private property rights is important, LEOSA generally supersedes private prohibitions for qualified individuals. This approach unnecessarily relinquishes the officer's legal right and potentially their ability to carry for their own safety, without exploring a reasonable avenue for clarification or accommodation. It bypasses the opportunity for a professional dialogue that could resolve the situation appropriately. Professional reasoning. Professionals facing similar situations should employ a decision-making framework that prioritizes proactive communication and de-escalation. This involves understanding one's legal rights and responsibilities, assessing the environment for potential risks or sensitivities, and then choosing the least intrusive yet most effective method to ensure safety and compliance. In the context of LEOSA, this means balancing the right to carry with the ethical imperative to avoid causing undue alarm and to foster public trust. A key step is to identify the appropriate point of contact within an establishment, e.g., security manager, owner, and to communicate clearly and concisely about one's status and intent. Question 19. A former police officer in Florida who retired in good standing 5 years ago presents a retired law enforcement badge and states they are LEOSA qualified and authorized to carry a concealed firearm under the Federal Law Enforcement Officers Safety Act. However, the officer's demeanor and the badge's condition raise a slight concern about the currency of their qualification. What is the most appropriate course of action to ensure compliance with Florida's LEOSA implementation and federal law? Option A. Accept the individual's statement and the badge as sufficient proof of LEOSA qualification, assuming their retirement in good standing implies ongoing compliance. Option B. Immediately inform the individual that their qualification is likely expired due to the time elapsed since their retirement and deny them the ability to carry. Option C. Politely request to see proof of their most recent LEOSA qualification certification issued by Florida, and if it appears to be expired or is unavailable, explain the requirement to requalify according to Florida's established procedures. Option D. Contact the Florida Department of Law Enforcement to inquire about the general status of retired officers' LEOSA qualifications without specific reference to the individual. The correct answer is C. Politely request to see proof of their most recent LEOSA qualification certification issued by Florida, and if it appears to be expired or is unavailable, explain the requirement to requalify according to Florida's established procedures. Explanation. Market research demonstrates that understanding the nuances of the Law Enforcement Officers Safety Act, LEOSA, qualification process is crucial for ensuring compliance and maintaining public trust. This scenario presents a professional challenge because it involves a potential conflict between an individual's perceived entitlement to carry a firearm under LEOSA and the specific requirements for maintaining that qualification. The challenge lies in navigating the legal framework of LEOSA while upholding the integrity of the qualification process and ensuring public safety. Careful judgment is required to balance the rights of qualified individuals with the responsibility to ensure that firearm proficiency is consistently demonstrated. The best professional approach involves verifying the individual's current LEOSA qualification status through official channels, and if it has lapsed, clearly and respectfully informing them of the requirement to requalify according to the established procedures for their state. This approach is correct because it directly adheres to the principles of LEOSA, which mandates that an individual must be authorized to carry a firearm and must meet the qualification standards established by their state. By seeking official verification and guiding the individual through the requalification process, the professional upholds the law, ensures the individual is legally compliant, and maintains the integrity of the firearm qualification system. This aligns with the ethical obligation to uphold legal statutes and ensure public safety. An incorrect approach would be to accept the individual's assertion of being LEOSA qualified without independent verification, especially if there is doubt about their current status. This failure stems from a lack of due diligence and a disregard for the explicit requirement of maintaining qualification. Ethically, this could lead to an unqualified individual carrying a firearm, posing a risk to public safety. Another incorrect approach would be to immediately deny the individual the ability to carry based solely on a suspicion without attempting to verify their status or offering a clear path to requalification. This could be seen as an overreach and a failure to provide the individual with the opportunity to rectify their status, potentially violating their rights under LEOSA if their qualification is indeed current or easily rectifiable. The professional reasoning process for similar situations should involve a commitment to verifying all claims against established legal and procedural requirements. When faced with a situation involving LEOSA, a professional should first identify the relevant state-specific LEOSA qualification requirements. Then, they should attempt to verify the individual's current qualification status through official records or by contacting the appropriate state agency. If the qualification has lapsed, the professional should clearly communicate the necessary steps for requalification, providing information on approved training and testing procedures. This systematic approach ensures both legal compliance and ethical conduct. Question 20. The risk matrix shows that LEOSA qualification compliance is a critical operational requirement for the state of Colorado's law enforcement agencies. If the Aurora Police Department has 250 sworn officers eligible for LEOSA qualification, and the average cost per officer for a qualification session, including range fees, ammunition, instructor time, and administrative costs, is $65, and their fiscal year runs from January 1st to December 31st, with the understanding that each qualification is valid for 1 year from the date of completion. What is the minimum projected annual budget required to ensure all officers are qualified throughout the fiscal year, assuming a steady state of personnel and no immediate need for new equipment? Option A, $17,500. Option B, $15,000. Option C, $10,000. Option D, $16,250. The correct answer is D, $16,250. Explanation: scenario analysis. This scenario presents a professional challenge due to the inherent tension between ensuring officer safety through regular qualification and the potential for financial strain on departments with limited budgets. The need to maintain a high standard of readiness for law enforcement officers under the Federal Law Enforcement Officers Safety Act, LEOSA, must be balanced against the practical realities of resource allocation. Misinterpreting or misapplying LEOSA qualification requirements can lead to officers being unqualified, creating a safety risk, or conversely, to unnecessary expenditure of public funds. Careful judgment is required to implement a qualification schedule that is both compliant and fiscally responsible. Correct approach analysis. The best professional practice involves a proactive, data-driven approach to scheduling LEOSA qualifications. This means analyzing the expiration dates of current qualifications for all eligible officers and projecting future needs based on the department's operational tempo and personnel turnover. By calculating the average cost per qualification, including range fees, ammunition, instructor time, and administrative overhead, and multiplying it by the projected number of qualifications needed over a fiscal year, a more accurate budget can be developed. This approach ensures that all officers remain qualified, thereby upholding the spirit and letter of LEOSA, while also allowing for efficient allocation of resources and avoiding emergency, potentially more expensive, requalifications. For example, if a department has 100 officers whose qualifications expire in a given year, and the average cost per qualification is $50, the projected annual cost for requalification would be \100 times $50 equals $5,000. This allows for planned budgeting. Incorrect approaches analysis. One incorrect approach is to simply budget for the minimum number of qualifications based on the current number of officers, without accounting for staggered expiration dates or potential new hires. This fails to recognize that LEOSA requires continuous qualification, and a reactive approach can lead to officers becoming unqualified if the budget is depleted before all necessary requalifications are completed. This creates a direct regulatory failure by not ensuring all officers meet the ongoing qualification standard. Another incorrect approach is to schedule all qualifications at the beginning of the fiscal year, regardless of expiration dates. While this might seem to ensure everyone is qualified early, it can lead to inefficient use of resources. Officers who qualify early might have their qualifications expire well before the end of the year, necessitating a second qualification within the same fiscal period if their initial qualification falls outside the department's defined qualification window for the subsequent year. This can inflate costs unnecessarily and is not a fiscally responsible application of LEOSA. A third incorrect approach is to only budget for qualifications when an officer's current certification is about to expire, without any buffer or proactive planning. This reactive strategy often leads to rushed requalifications, potentially at higher per-unit costs due to last-minute arrangements or overtime for instructors. It also increases the risk of an officer being temporarily unqualified if administrative delays or unforeseen circumstances prevent timely requalification, thereby failing to meet the continuous qualification mandate of LEOSA. Professional reasoning. Professionals should adopt a continuous improvement mindset when managing LEOSA compliance. This involves 1. Maintaining an accurate, up-to-date database of all LEOSA-qualified officers, including their qualification dates and expiration dates. 2. Regularly reviewing this data to forecast future qualification needs. 3. collaborating with finance departments to develop a realistic, proactive budget that accounts for the projected number of qualifications, associated costs, and potential contingencies. 4. Implementing a staggered qualification schedule that aligns with expiration dates to ensure continuous compliance and optimize resource utilization. 5. Periodically reviewing and updating the qualification process to incorporate best practices and address any emerging challenges.